After a lot of deliberations, we are here to open up this Pandora box of KOA versus KCS in Karnataka. In the recent times, there has been a lot of disturbance or inconvenience to the apartments which have started their cooperative societies. We would like to clarify certain false information spreading within the community and the offices of the departments concerned. Now, after buying apartments in Bangalore, we form an association. Now, why do we need these associations? Because we need to manage the day-to-day affairs of maintenance in the apartments. So initially, there were many of the apartments had formed Society Registration Act 1960. The another enactment which came in was Karnataka Apartment Ownership Act 1972. The same year another enactment came, Karnataka Ownership Flat Act 1972. And another legislation was Karnataka Cooperative Societies Act 1959. With these kind of 5 legislations together, people are finding it difficult, which is the right one, which is the wrong one. Now, why do we have this? Maintenance, of course, but post this enactment of RERA 2016, the conveyance of land becomes a mandatory subject, wherein conveying party, the builders, need a juristic body or a corporate body which can own the property of the land which is to be conveyed. KSRA societies which were formed were quashed by the Karnataka High Court because, as per the statute, they are not in a position to collect maintenance and govern or manage the maintenance of the apartment. So left were KCS and KOA. KCS is a format which is very much in practice and successfully managing other parts of the country, mostly Maharashtra, Telangana, Delhi, everywhere. In Maharashtra, of course, it has been, I think, 50, 70 years. This is successful in managing the affairs of the apartments. Here in Bangalore, it has recently started with the IT revolution. Now, post-RERA, there has been a lot of objections, obstructions to these cooperative societies by the builder lobby. Many cases have been filed. Many people were attacked. A lot of difficulties people are facing in the cooperative societies of these apartments. That's mainly because of land transfer from builder to the apartments. Now, for KCS societies, Karnataka Cooperative Societies, the competent authority is the Department of Cooperative Societies, whereas KOA Association is an association formed under 1972, they claim, but there is no such association formed or registered, even though they claim that bylaws are registered with the registrar's department. But the IGR has submitted a written statement to the Karnataka High Court saying that the Department of Registration do not register any associations. Whatever document is given to them is usual practice, they register those documents. Here it is the deed of declaration which is submitted to the sub-registrars, which get registered as a document only. They don't register associations. So they don't get a registration certificate like the societies which are given the registration certificate with the registration number. Because of this, the cooperative societies become eligible to sue, get sued, to sign the contract and own the property. In one of the cases, the Apex Court has held that Sobha Hibiscus Condominium versus Managing Director, Sobha Properties Limited, the Apex Court has held that these KO associations are not voluntary associations and cannot sue or get sued. They cannot sign any contracts. Now, under these circumstances, the KOA association running the management of maintenance of apartments are illegally managing it as per the orders of the Apex Court because they signed contracts as of now. And it's also learned that some banking organizations have issued show cause notices to chartered CAs who have cleared those accounts of these KO associations. I would like to add few points from the law books. Karnataka Real Estate Regulation and Development Rules 2017 Ladies and gentlemen, kindly note here, it clearly says registered under any law for the time being in force, acting as a group to serve the cause of its members. So, RERA rules mandates that the Association of Allottees should be a registered body. KOA is not registered body. KCSA is registered body. So indirectly this RERA conveys to us that the only body which can hold conveyance or comply with RERA provisions is the Karnataka Cooperative Societies formed under KCS 1959. Coming to the next provision of the clause 2C, it defines cooperative society specifically, but it never defines KOA here. So that means this KRERA rules 2017 clearly states that it is a cooperative society which need to be formed in the apartments. Looking at the KOA provisions itself, Karnataka Apartment Ownership Rules 1974, Rule 4.2, which says the declaration shall be signed by the apartment owners and verified in the presence of a magistrate or any other person competent to administer oath, and shall be filed with the competent authority within 30 days from the date of its execution. In this one rule, there is one requirement, which is magistrate. Every owner has to sign in front of the magistrate to verify that he is the real owner. Second is, it has to be filed with the competent authority. I am sure these two provisions are not at all complied by any of these KOA associations till date. As of now, KOA, according to the existing situation in the law, is not legally competent to administer the affairs of the apartments. Only cooperative societies formed under KCS 1959 are fully eligible and competent with the law, within the law, to manage the affairs of the apartments effectively. And 45 societies which are registered recently are running it effectively. Misleading the Court of Karnataka, there are some judgments which have been taken in the case of CRP 96, DX Max 57564, DLF Maidan, which is the recent one. All these cases have a different set of facts and issues. And there are some judgments in favor of the cooperative societies, at least 2 or 3 of them. So under these circumstances, still cooperative societies can fight it out to win the battle against the illegal KOA associations.